Our next speaker, live from the state of Virginia, Brandon Butler, who works for the Software Preservation Network, who we heard Neil Chu-Hong talk about briefly this morning, who is the Director of Information Policy at the University of Virginia. So I will stay here just in case anything goes drastically wrong with our remote connection, but I will hand it over to you, Brandon, to take it from here.
Great. Thanks. Hi, everybody. Thanks for letting me Zoom in from Virginia, where it's only just now morning. So I'm sorry I haven't been able to watch the full day's events, but I'm thrilled to join you. And I'm going to talk to you a little bit about the law and policy agenda that we've developed and that we're starting to pursue in the Software Preservation Network. So first, let me tell you about the Software Preservation Network. It's a nonprofit organization based in the US. It's a coordinated, distributed effort to ensure long-term access to software through community engagement, infrastructure support, and knowledge generation. That means it's a group for folks like you all. And I'm sorry, I'm hearing an echo of myself here. Maybe if you guys could mute the room while I'm talking, that would help. But it's meant to solve the problem of uneven distribution of expertise and resources and collections around software, right? Software preservation is challenging. It requires really sophisticated expertise. It requires a lot of resources, and software collections themselves are sort of scattered hither and yon. It's not like every institution has a robust collection. And so Software Preservation Network is meant to help solve all of the problems that come from that uneven distribution. We've had generous support from the Alfred P. Sloan Foundation, Andrew W. Mellon Foundation, and the Institute for Museum and Library Services here in the US. And I've been focused for the last couple of years in working with SPIN on a couple of law and policy projects. And we're really proud of these accomplishments. They actually date to before SPIN and really came to fruition alongside of SPIN. The first is the Code of Best Practices and Fair Use for Software Preservation, a kind of guide to the use of the US Fair Use Doctrine for software preservation practitioners. And we secured a new regulation in the US, an exemption that allows software preservation practitioners to crack digital locks in order to preserve the software in their collections. So we're really proud of those accomplishments. And I'm going to talk now about a few things. First, I'm going to talk about why we're focused on copyright as the sort of soul of our agenda around law and policy. I'm going to talk about what I consider to be a problem with a permissions culture that's developed over time in the software community. Something that we documented in the first phase of our best practices research. And then I'll talk a little bit about what I characterize as self-help, things that we've been doing and that we can continue to do within the community, amongst ourselves, to improve our situation around law and policy. And in the US, we've been focused on fair use and the DMCA, but as I'll explain later, I think these principles are easily exportable. And I'll talk a little bit about, finally, permissions themselves and where they come in and why they come later, why we focused on self-help first. And finally, I'll talk a little bit about exporting all of these ideas outside of the US, because I'm an American lawyer, but I want to assure you that these are not purely American ideas. So first, why copyright? And this may not take too much explaining probably in this room, but software, of course, is, at least in the US, it's classified as a literary work. I'm not positive that's exactly the nomenclature in other countries, but software is protected by copyright, right? It is a regulated work that is treated as a kind of intellectual property. And so the protection for software that we have to worry most about is copyright protection. You know, there are other things that can come into play. Contracts certainly can be important, and we can talk about that. But in terms of, the default rules that govern this subject matter, it's mostly copyright. And software preservation involves activities that are the kinds of activities that copyright cares about, right? Copying, modifying and altering, adaptation, distributing, circumventing technical protection measures. These are the sort of things that you need to do your job, are also things that copyright law tries to regulate and bring under the control of the copyright holder. So it's really important to understand how your activities are scanned by the law. And in the US, this is, I think, not so true elsewhere, but in the US, copyright liability carries a really stiff penalty. There are statutory damages in the tens of thousands and even hundreds of thousands of dollars if you're working with more than one copyrighted work. So the consequences of getting copyright wrong can be quite dire. So that's why we're focused on copyright. So when I first sort of joined this community and started to learn more about the way copyright affects your jobs, the first thing I did was, along with my co-investigators on the Code of Best Practices project, we had a grant from the Sloan Foundation to do some research in the community and to develop this code. The first thing we did was to find out, well, what happens right now when you hit a copyright question or you feel a kind of copyright anxiety? What do you do? What do you think is the answer? How can you alleviate the risk that you feel is caused by copyright law? And we conducted a series of confidential interviews by telephone with, I think, ended up being more than 40 people practicing in all kinds of institutions, from government archives to, privately held collections, asking them these questions about, how do you manage copyright anxiety? When does it come up and what do you do? And over again, we were told that software in particular really is something where you can't be sure that you're safe unless you have permission to do what you want to do. And so what we found was a really pervasive permissions culture in software preservation, a sense that especially in software, this was exacerbated because there's a long history of software licensing, right? Unlike, say, vinyl records or books and magazines, software, purchasers for years now have sort of at least dimly understood that what they're doing is not exactly a purchase in the normal sense. It's a contractual relationship in many cases, where even though you may, even in the good old days when you sort of went and bought a box that had a disc in it and you gave the cashier money and you walked away with a physical thing, when you opened the box, there was some shrink wrap license, language on it. Or when you first put in the disc and ran it for the first time, you had to click on something that says, I understand that these are things I can do and these are things I can't do. So a really pervasive permissions culture had been inculcated in the community, a sense that, software was sort of radioactive and there's nothing we can do unless we've been given permission affirmatively by the copyright holder. And that was really stifling practice. Folks were doing what they thought they could get away with, doing what they thought that if they, if nobody knew about it, it would be okay. And, really circumscribing their practice based on fear of retribution from copyright. And there's a real problem with seeking permission in this context. And again, I'm sort of probably talking to people who know this better than I do. But permission is really hard to obtain. And there have been well-documented, well-publicized, well-funded, large-scale efforts to seek permission to use software. Henry Lowood at Stanford, I think, has one of the best use cases that I've heard of. And they fail. They fail for a number of reasons. One is there's really no business model for preservation. The companies don't know how to route your phone call, right? You call them and say, I'd like to pay for the right to keep this in my archive and make it available to scholars and students. and they don't really have a model for that, especially when this you're talking about is software that's 20 years old and they don't even have a copy anymore. So there's not a business model. There's nobody to take your phone call. There's not a rate sheet. The rights situation is unclear. So especially, the further you go back in the mist of time, the various components that go into a particular piece of software could have been created by developers who were under different kinds of arrangements with the software publishing company. And I've heard over and over again stories about preservation curators and technicians who finally got in touch with like the founder of a software publishing company. And that guy said, I don't know if I can give you permission. It's fine with me if you want to do that, but there's music on that software title. There's images that we paid graphic designers for, and I don't have that paperwork anymore, and that guy is gone and I can't find him. And so what you also find is, the rights kind of unravel over time, and it's difficult to know who owns what. And closely related to that is the phenomenon of rights holders disappearing. So, again, over time, software is a volatile industry. It is a very future-focused industry. Companies come and go, they're absorbed and spun off, and people don't keep good track of who owns something if it's no longer profitable, right? If something is no longer being sold, there's not necessarily a good incentive to keep track of who owns it and what we're willing to license it for, and so on and so forth. So again, even assuming that permission was an appropriate strategy, and assuming that even assuming that you could find a rights holder with goodwill, it turns out there are deep challenges. So that's why we've focused our initial efforts on fair use. Permission is not necessarily the only solution to copyright challenges. And this is true across the board. This is true for critics and news reporters and poets and anyone who needs to use copyrighted works in their daily practice, where interacting with copyrighted works is really a part of their professional identity. Those folks don't always need permission to do the jobs they do. And in the US in particular, fair use has been popular, but in general, copyright is meant to be a kind of balanced system where there are rights for users and the public and cultural stewards, as well as rights for creators and publishers and commercial interests. And so, the copyright systems around the world typically aim for some kind of a balance that yields, appropriate rewards and recognition of moral rights, if that's what you're into, for the folks who create content, but at the same time doesn't prevent legitimate activity by others, especially folks like cultural stewards, cultural heritage institutions, when that activity is really socially beneficial and is not going to harm the market. And so in the US, fair use is really kind of central in our system of limitations and exceptions because it's a flexible and open-ended exemption. It can apply to any number of situations. It's not specifically or narrowly defined. There are specific exceptions in our copyright law, and that look like a lot of the specific exceptions that you find in laws around the world that say, well, you can make 3 copies for the purposes of preservation, but it has to be a work that you own, and those copies have to be kept on site. And, they're very tightly regulated limitations and exceptions, but fair use is much broader than that. It's meant to be a kind of catch-all exemption for all socially beneficial uses that do not harm a copyright holder in a way that, we're concerned about. I mean, every copyright holder can say, I should have been paid, and so I was harmed. But what fair use allows judges to do is to say, well, sometimes we care about that and sometimes we don't, depending on exactly the nature of the use and the user. Judges have defined the scope of fair use over time in the US. Similar activity happens in Canada and the UK, common law countries where judges can evolve doctrine. But scholarship that has come out in the last decade or so shows that even civil law countries where, you know, the law is not so much judge-made on its face, in those countries, judges have to interpret the law, and they look to one another for guidance on the best way to interpret the law. And so even outside of the US, you can find some flexibility in the way the law can be applied. And when there are gaps in the way judges are applying the law, when the proper interpretation is sort of contestable, there's room for users to step into those gaps and sort of declare best practices that are lawful, legitimate, balanced, reasonable, justified, and provide for themselves the guidance that's sort of missing from the case law. And so that's what we've done with the best practices, the Code of Best Practices in Fair Use for Software Preservation. We've identified 5 common situations where copyright affects software preservation practice, and how fair use can apply to those 5 situations. And they describe a software preservation workflow that moves all the way from, you know, you've got a floppy disk and you don't know what's on it. You've got to migrate that to a stable format, all the way out to the kind of stuff that Klaus was just describing, you know, a networked environment of emulated software that allows access to digital artifacts for research. So we've tried to really cover the waterfront with the best practices and fill in gaps where, frankly, people don't sue libraries that often, even in the US, where we like to sue people for all kinds of things. And so there's no case law on this issue. Judges have never said, how does fair use apply to software preservation? So we have to work by analogy. We have to use the general principles of fair use and apply them ourselves using our own judgment. And so that's what we've done. The next form of self-help that we've engaged in involves circumvention of technical protection measures. And this is a global issue. I apologize on behalf of my country because we did this to you. The Digital Millennium Copyright Act was passed in the late 90s in the US after the WIPO Treaty was adopted at the urging of the US. That forced all signatories to adopt this kind of anti-lockpicking mechanism. It was a kind of policy laundering. So the rights holders couldn't win in the US, and so they sent the US government that was friendly to them, but not quite capable of passing a law. The Clinton administration sent someone to Europe to WIPO. They pushed very hard and were able to convince the world that this should be a worldwide thing. And then he came back to the US and said, you know, oopsie daisy, there's a treaty and now we have to pass a law whether you want to or not. So again, my apologies, our fault, our bad, trying not to do that again. But anyway, so now we have a system, you all have systems analogously, that says it is a separate violation, not separate and apart from copyright infringement. It is a violation to pick digital locks like encryption, or to hack digital protection measures like dongles, authentication servers, all the things that make it so that you can't open software. If you can hack those things, that hacking itself is a violation of US law and analogous laws around the world. In the US, though, there's an administrative rulemaking every 3 years in which anyone can participate and in which the Librarian of Congress, on the basis of recommendations from the Copyright Office, grants exemptions from this ban on lockpicking. And so every 3 years, advocates from the public interest community, and in particular, lots of advocates from higher ed, libraries, and cultural heritage institutions, converge on the Library of Congress, and they bring with them evidence of how the DMCA is stopping them from doing their work. And there had never been a broad, all-purpose sort of software preservation exemption until this most recent cycle. And I was really struck by that. And I was struck by that in particular because I knew from our research that picking digital locks was something that was really making people nervous. A lot of people were doing it, but they didn't want to talk about it. And they were afraid that if they got caught, they might get in trouble. And so here was a chance for us to tell that story that, hey, this is our digital cultural heritage at risk. If we can't pick these locks, we won't be able to save these programs. People won't be able to study them. And we convinced the Copyright Office that that was true. And we received 2 broad exemptions to allow us to pick the locks on utilitarian software and video games. So that covers the waterfront. In order to secure those exemptions, I think it's important to point out, we had to prove that the underlying preservation activity was lawful. That is, the Copyright Office is not going to let us pick locks if what we want to do after we pick the locks is copyright infringement. And so what we do have now, interestingly, is a kind of acknowledgement from the United States Copyright Office that software preservation without permission is lawful. They brought in other doctrines. We brought in fair use, but there were other, the specific exemption for preservation was also invoked. And so, you know, it wasn't a total fair use victory. It was a victory with a bunch of different legal elements to it. But the bottom line is, again, we do have a kind of government agency, an expert copyright agency saying it is lawful to preserve software without permission. And so they granted us an exemption to do that. And the rules, of course, were written by and for lawyers. And so they are hard to parse. And so the next thing that was really important for SPIN to sponsor was a kind of translation for the community. And so we have the Harvard Cyber Law Clinic at Harvard Law School that's been working with us for years now. And the students there created a wonderful sort of lay person's guide to the DMCA exemption that turns all of that kind of legal mumbo jumbo into language that you can understand so that you can determine, you know, whether and how this exemption permits you to do what you want to do. So we've had these 2 self-help projects, and so far so good. Both of these have been really, I think, useful to the community. We've seen people taking advantage of both of them already, and both are barely under a year old. And in less than a year, people are already, I think, taking advantage of these new tools. So we're working on doing what we can without asking anyone's permission. But, right, sooner or later, you're going to want to ask permission, right? Why should we ask later? Because it's my position that we should wait. It's my position that you need to understand what you can do without permission before you go trying to develop a new permissions regime. And as Klaus, again, toward the end of his presentation, I mean, I'm afraid the problems that he outlined are really, in a way, the Death Star for copyright limitations and exceptions, because the copyright limitations and exceptions like fair use, like exemptions for libraries and archives, you still have to physically have the thing before you can preserve it, right? And so Congress can say, or the Parliament can say, yes, if you have software in your collection, you can make copies without asking. That's fine. But if it's in Google's cloud and we can't get our hands on it, what are we to do then, right? And so we are, I think, going to have to sooner or later have these conversations. But it's important, I think, to understand and to develop a community consensus as much as we can at the broadest level that we can about what our rights are without permission before we go and ask for permission. Why is that? The first is, if you're familiar with the negotiating classic, Getting to Yes, BATNA is your best alternative to a negotiated agreement, right? So when you go into any negotiation, you need to know what's the best you can do if you can't come to an agreement with this person, because that tells you what you're willing to give up in order, or what you will gain, what you stand to gain from negotiating is relative to what you already have, right? And so you need to know, what happens if we walk away? How bad off are we going to be? because if you walk into a negotiation situation thinking that without permissions we're sunk, and without permissions, there's no hope for software preservation, well, then you're willing to give up a lot, right? You might be willing to negotiate away a lot more of your rights, or you might be willing to pay a much higher price than you would if, as I think is the case in the United States, getting permission is sort of a nice thing to have, but probably not necessary. It doesn't hurt. It can actually give a lot of people additional comfort. It could be a way to start a conversation with industry that's useful and productive. But worst comes to worst, we can preserve software without permission. And so that's an important thing to know before you start asking. Solidarity and consensus are really important, right? Because you don't want to have sort of 5 different entities negotiating deals with 5 different levels of expectation and coming out with 5 different, arrangements that are, some of them might set terrible precedents for the others, right? If one person goes in with a different set of assumptions about how important permissions are, they may create a deal that becomes a template and set expectations among industry in a way that's harmful to the others. So you want consensus. You want to protect your rights. If you know that fair use lets you do something, you want to be sure that you don't end up worse off after a permissions regime. So, I'm really also interested in open access and research. And I was following the deal that France recently struck with Elsevier, the Couperin Consortium. Struck a deal with Elsevier, and I think one thing that really made many French open access advocates upset is that they lost some of the rights that they would have had if there was no deal at all, because France has a really nice legislative requirement that permits authors to submit their journal articles 6 months after they're published into the National Open Repository. But under the deal with Elsevier, they would have surrendered that right. So you want to know what rights you have, and you want to try to hold on to them and not surrender them. And then finally, I'm really wary of getting into a licensing situation because for legacy content, the software publishers really have a monopoly on that content. No one else can sell us Word, right? So we really don't want to be over a barrel in that way. And I'm sorry, I'm going to move more quickly because I have to go, and I know you're running behind. Legislation, I'll just say, in the U.S., nothing ever happens. It's easier to kill something than to pass it. And we're also really tired of copyright around here. Our legislature is afraid of copyright. It feels like a third rail. Nothing good ever happens when you try to mess with it. So I'm not optimistic about legislation. And my understanding is that may be true to some extent in the EU because of the copyright directive. It's like we've spent all of our energy on that. But on the other hand, thinking about exporting, in the EU, cultural institutions, I think, have more clout than they do in the US, and industry has less clout than they do in the US, maybe. And so it could be that, the legislative environment could be better, but on the other hand, there still could be fatigue from the copyright directive. The work that I've done so far is US centric, as I've said, but all copyright systems have limitations and exceptions. Some are very closely analogous to ours. Fair dealing in Canada is has almost converged completely into fair use. So we're already talking to scholars there about exporting the best practices, more or less word for word, to Canada. But in general, you need local legal expertise. I'm an American lawyer. I was trained in American law school. You really want to talk to someone in your jurisdiction, but talk to someone in your jurisdiction who is sympathetic to the limitations and exceptions agenda. There are some copyright lawyers who they are also trapped in a permissions culture. They see everything through the lens of licensing. But there is a growing cadre of copyright lawyers and scholars who I think are more attuned to the value of limitations and exceptions. And one thing SPIN, I think, is interested in doing is identifying those folks around the world and helping to match up our colleagues with their lawyer counterparts to have those conversations. So thanks a lot. I'm sorry. I think I've probably run long too. And I've got to run to another meeting at 10 o'clock. So I will take your questions for the last couple of minutes and then run away.
Thank you. Brandon, can you hear me? Just to make sure the sound is working the way that I think it is. Yeah, okay.
Yes, I hear you.
So we've actually, we have overrun, but since we have you and you have to run, we could maybe take one question. If anyone has a really, we've got Roberto Di Cosmo who spoke earlier.
Yes, now it works. Okay, so thanks, Brandon, for this overview of the situation in the US. Actually, more than a question, it's a comment. I mean, in the EU, you know, we have just voted a new reform of copyright, right? It was voted in April, past April. Here we have precise exception for cultural institution. Did you have any chance to look at this?
Did you catch that, or should I repeat it?
I sort of caught it, but not quite. It's very echoey on my side.
So
I'm sorry.
It's okay. Roberto was commenting that there has been a recent reform in the EU to copyright, and that there is a very precise exception for cultural heritage institutions. And if you were aware of this.
Yes, and so I'm as aware as an American lawyer can be expected to be, right? But yes, there was an upside to the copyright directive for cultural heritage institutions in several aspects. So it wasn't all linked taxes and filters. There were a few good things in there. The full nature and extent of the good things, though, I'm not fully read up on yet. But this is where I think it's really important, I think, to engage your local experts and start digging in and trying to make the most of those exceptions, because they're not nothing, and we should take advantage of them.
All right, Brandon, well, we'll let you go. But I see you've put your email up here, so I would encourage people, if you do have follow-up questions for Brandon, to get in touch.
All right. I'm hearing silence, so I'm guessing maybe we're done. And I've got to go to my 10 o'clock appointment.
All right.
So
thank you, Brandon.
Thanks. Bye, everybody.
Bye, Brandon. Thank you very much.